Good afternoon, and welcome to The Insurance Lawyer, the podcast where we discuss topics concerning claims and lawsuits between insurance companies and their policyholders. I am your host, Evan Schwartz, founding partner of Schwartz, Conroy & Hack. The firm represents business and individual insurance policyholders in claims and lawsuits against their insurance companies, helping policyholders get their claims paid. Today, we are going to discuss a continuation of the topic that I had started on my last podcast concerning long-term disability claims. And today's discussion is going to focus on the things that need to be considered when you are going to sue your insurance company for not paying your long-term disability claim. And there are quite a number of issues that you need to think about when that happens, depending on your circumstance and the manner in which the claim was denied and for what your claim was denied about. So let's start with the first thing which you need to identify is if your claim was denied, who was it denied by? What insurance company and what type of coverage did you have? So did you have group insurance? If you had group insurance, it's very possible that your long-term disability claim may be governed by a federal law called ERISA. ERISA stands for the Employee Retirement Income Security Act of 1974, and basically it is a law that governs the handling of employee benefits claims. Now there's many podcasts, seminars, and legal seminars we could have about ERISA. But the most basic things I want people to know about when you have an ERISA-governed claim is first, was there a requirement that you file an appeal before you start a lawsuit? And did the policy require that you file an appeal? Because across the country, if you don't appeal a denied or terminated claim that is governed by ERISA, and there is an appeal requirement contained in your policy or group plan, then you will be thrown out of court and may lose your case forever if you don't appeal. In legal terminology, they call that exhaustion of your administrative remedies, which means you have to do the appeal, assuming that your claim is going to be governed by ERISA and that the policy has language requiring an appeal. So if you haven't done your appeal, you can't go to court and you need to deal with your appeal. ERISA appeals are a whole separate animal in and of themselves, and in one of my upcoming podcasts, I will be discussing preparation of an ERISA appeal with my partner, Michael Hack. But for now, that's one of the first things you need to figure out. If your claim is governed by ERISA and you have done your appeal and the appeal was unsuccessful, now you either walk away from your claim or you sue. Now, if you're going to sue under ERISA, the first thing you need to know is that your case is going to wind up in federal court. ERISA is a federal law, and the vast majority of all cases decided under ERISA in this context get fought in federal court. So you need to make sure that you have a lawyer that's comfortable with and understands that they're going to have to litigate this case in federal court. I will tell you as an aside, the law does allow a state court to actually hear and determine a claim that's governed by this federal law called ERISA, but the cases almost never wind up in state court because the insurance companies have the right to bring them into federal court. Even if you sue in state court, they can take the case and bring it to federal court. It's called removal, and they will almost always do that. So the only chance that you're going to wind up in state court is if you brought it in state court and the law firm for the insurance company made the mistake in their mind of not bringing it to federal court through removal. I've had one or two cases throughout my entire career that litigated under ERISA in state court, which I will tell you was like litigating in the wild, wild west because the judges had no idea what ERISA was. They didn't understand the rules surrounding ERISA, and they all freaked out, even though it ended up well for my clients because they treated it like a regular type of contract lawsuit, which was beneficial to my clients. But putting that aside, so let's assume that your policy is not an ERISA governed policy, and I don't want to say individual policy, but and the reason I don't want to say that is because there are certain policies that you may think are an individual policy that may be governed by ERISA, which is you're going to need a lawyer that understands this stuff to evaluate whether that's possible. But assuming that it's a policy you purchased on your own had nothing to do with an employer, or for other reasons is not going to be governed by that federal law, ERISA, then you're going to be determining what court you want to bring the case in. Now, insurance companies want these cases to be litigated in federal court. And there are a variety of different reasons for that, but it's not necessary for us to really get into the details concerning that right now. There are two ways you can get into federal court and two ways these disability litigations can get you into federal court. One is that it's governed by a federal law, like ERISA, which automatically means the federal courts can hear it. Another is something called diversity jurisdiction, which any case could potentially qualify for. Basically, you, the plaintiff, assuming you're the plaintiff, and the defendants have to be citizens of different states, and there has to be at least $75,000 in dispute. If that's the case, then you can bring the case to federal court. If that is true and you bring the case to state court, the insurance company can take you into federal court. So when you're looking at litigating one of these cases, you have to figure out, well, what court am I likely to wind up litigating this case in? And if I think I want to file in state court, but the insurance company is probably going to drag me into federal court, that should be something that you're thinking about when you determine what you want to do if you're the one that's going to be bringing this lawsuit first. And so determining what court you're going to be in is pretty important, because ultimately it may be that there are certain judges that you'd prefer to get in that particular court. There are certain law and interpretation of the law that are better in that particular court. And you have some control over that when you're first thinking about filing that lawsuit. Now, when you're thinking about that lawsuit and you're a lawyer representing a client in one of these cases, you're going to be doing some pre-lawsuit filing due diligence. And what kind of due diligence are we talking about? Well, you're going to want to know as much of the facts surrounding your case as possible to understand what happened, why it happened, and whether or not those facts affect what you're going to do. There are many, many, many complicated things that go into this sort of a soup, but the first question is going to be, again, does federal law ERISA govern your case? Does state law govern your case? Because if it's not federal law, then it's going to be state contract law and maybe state tort law that governs your denied or terminated disability claim when you get to court. So, for example, if you are a resident of the state of New York and you have a case that's not governed by ERISA and you're going to file it, New York law interprets things certain ways. If you have a case that's not governed by federal law and you're going to file it in California, California has another way of looking at certain things. And I will tell you right now, New York law is very good for the insurance companies and pretty crummy for the insureds or the disabled people. California has great law for individuals and crummy law for the insurance companies when you get into these cases. And so determining whether your case is going to be governed by ERISA is extraordinarily important. First of all, because if it's governed by ERISA, the state laws that give you certain advantages and remedies are not going to apply if your case is governed by ERISA. There's a concept in the law called preemption, and preemption is where a federal law is deemed to be so comprehensive that it supplants and replaces all the state law surrounding it. So why that's good for insurance companies and bad for disabled people is because if ERISA governs, it is deemed to preempt state law. And that means if there are great state laws that help insureds who get shafted by their insurance companies, denied or terminated, they're not going to be able to access those laws. So what kind of laws am I talking about? Well, the most important one I'm talking about now is bad faith. In New York State does not have first-party bad faith where you could really get remedies beyond what you're entitled to under the policy. California, on the other hand, has incredibly great law that treats bad faith as a tort where there are extraordinary remedies available to a person whose claim was wrongfully denied or terminated by an insurance company. And they can get money well beyond the contract. They can get punitive damages. They can get counsel fees. They can get claims for a mental and emotional distress. All kinds of remedies in addition to what the contract provides for. So determining, one, whether or not you have any ERISA involvement in your long-term disability lawsuit is paramount, followed by, if not, what state's law is going to apply to your particular claim and policy. And that's going to inform the attorney in terms of where they're going to bring suit, what they're going to ask for in the suit, and what's going to happen when the insurance company responds to the lawsuit. So those are all some very, very important pre-suit investigation thoughts that you need to have when you're evaluating a litigation in one of these cases. Okay, so those are some of the initial basics. In addition, the pre-suit investigation should also be, if you're representing an individual who was denied or terminated, you want to get as much of the facts as possible. You want to get the medical records, all the policies, the claim file from the insurance company if you're entitled to it. If your claim is governed by ERISA, you're going to be entitled to see the entire claim file, both all of the claim file that surrounded the decision by the insurance company to deny or terminate the claim in the first place, and all of the information they relied on in deciding the appeal. You get to see and look at, and that can inform what you're going to do in the lawsuit. In addition to having the medical records, the policies, and the claim file if you can get it, doing a good full background and social media search on your client is very, very helpful to make sure there isn't anything that you're going to have to address with your client or anything you see that's a potential problem or potentially inconsistent with whatever's going on in connection with the case. This is especially important because when you're assessing the merits of the case and you are representing a policyholder in one of these cases, you're asking someone to invest a lot of money in litigation, or you as a lawyer are going to take the case on a percentage and put your time, energy, and effort into it. So the due diligence you need to put in to determine whether or not the merits of the case are as good as you believe that they are and as good as that preliminary due diligence shows you is extraordinarily important, both for the client and their expectations and beliefs, as well as the lawyer and their ability to manage the client relationship, get paid for their services, whether pay-as-you-go, contingency, or otherwise. So on both accounts, the pre-suit investigation is extraordinarily important. Okay, I'm going to just cover one other small area of this for now, and I'm going to talk about what happens once you get into court, because people get confused about litigation and the stages of litigation. If you're in a lawsuit about disability, and the issue is the person disabled or aren't they, that's usually a blend of medical, occupational, and personal information that you're going to have to gather and prove. And 99.9% of the time, if the question is, are you disabled or aren't you disabled, that question is going to be resolved only by a finder of fact. A finder of fact is going to either be the judge who's assigned to your case or a jury. And if the case is going to go to trial, either the judge or the jury is going to decide those facts. So evaluating your client's credibility, both the insured and the insurance company, the disabled individual and the insurance company, for purposes of understanding where this case is going and how to get it moving forward as you prepare to file your lawsuit and move forward with the legal process. A lot of people always think of litigation as trial, but litigation is not just trial. Litigation is everything from the filing of the lawsuit until it's over. It's just that before trial, we call it pre-trial litigation, and once you go to trial, it's called trial. So I get a lot of clients who will say to me, well, if this goes to litigation, and what they really mean is if this goes to trial. But the reality is, if you can't get the insurance company to reverse their decision to not pay you, and you can't get some kind of a lump sum settlement, then litigation is going to be the filing of the lawsuit. Now you are in litigation, and all those facets of litigation are going to be things that you need to address. And most litigations are going to end only 3 different ways. Lawsuits end typically if they're going to be fought to close to conclusion. The first is they settle, and the vast majority of cases settle. And a settlement is that Both sides decided to take a dollar amount and pay a dollar amount that they agreed upon, wasn't required by the contract, and they decided to sign a settlement agreement. I'm going to take, you're going to pay it, we're going to part ways and never do business again, and we're going to sign an agreement where nobody admits did anything wrong, and we're promising not to tell anybody about the circumstances of it, except for our accountants and lawyers and professionals who we need to advise us on this, and we're going to be done. So settlement is your most likely outcome of any one of these litigations. The second most likely outcome, if it applies, is that there's going to be some motion, like a summary judgment motion or something, that's going to be dispositive of the outcome of the case. It's going to decide the case. Someone's going to win, someone's going to lose. And then finally, the other way that they get settled is to go to trial and get a verdict. So those are your three primary ways that it happens. The first is settling. The second is some type of a motion. And the third one is a trial. Now, the important difference between a contract case like this, a long-term disability litigation, and, for example, a bodily injury or personal injury case, is that these cases are all or nothing propositions. You either win everything or you get nothing. In the personal injury context or the bodily injury cases, there's usually an apportionment of fault. So, to use round numbers, if the plaintiff is 50% at fault, the defendant is 50% at fault, and the damages wind up being $200,000, then the defendant has to pay the plaintiff half of that for the 50% of fault, or $100,000. But the plaintiff, even at 50% fault, still going to get half. In a long-term disability litigation like this, it's an all or nothing proposition. You're either going to win and get your benefits, or you're going to lose and get nothing. There's no in between. And so the risk component to it related to the potential outcome is much, much higher. And it requires a lawyer with a good understanding and a level of transparency with their client so that their client truly appreciates the risk that they're taking when they evaluate and determine whether or not to settle and for how much money, assuming a settlement offer is available and it's an option, or what problems they need to counter and what risks they need to take in terms of whether the client is going to be paying expenses or paying the legal fees. In all these scenarios, there needs to be an appropriate level of education of the client, of a full understanding of the likelihood of the outcome here, whether it's going to be some kind of a settlement, whether it's going to be some type of a dispositive motion like a summary judgment motion, or whether it's most likely to go to trial. And everyone needs to understand, especially the public, that lawyers are always basing it on their educated percentage evaluations. So what I'd say, the educated percentage evaluation is a assessment of your risk and your possibility of your outcomes. So if your lawyer is effective and understands the risks of settlement versus some kind of summary judgment or dispositive motion or outcome at trial, it's very important for you to, as a client, to really listen to those and think about those things and process them in as much of a non-emotional way as you can, because if you decide to roll the dice and that rolling is inconsistent with what your lawyer advised you and you lose everything, you're not going to be happy. So it's very important that your lawyer has a sufficient level of understanding and expertise in this area to give you the advice and the appropriate risk assessment. And it's very important for you as a client to carefully consider that. Anyway, I appreciate y'all listening today. Thank you. And if you like the podcast, make sure you leave a review and subscribe so you don't miss an episode. You can visit Schwartz, Conroy, and Hack PC, our website at www.schlawpc.com for more information. I am the insurance lawyer. Have a fantastic day.